Broadcasting from the studios of Business RadioX, it's time for Litigators Lounge. This show is brought to you by Hall Booth Smith, guiding clients through challenging workplace legal issues. Now, here are your hosts.
Good morning, good afternoon, good early evening. Thanks for tuning in, everyone, to this week's episode of Litigators Lounge, where courtroom drama meets the comfort of casual chat and a cocktail. I'm Jackie Voronov with Labor and Employment Group at Hall Booth Smith, and I'm here with my ever-terrific co-host, Shylie Bannon, out of Jacksonville, and I'm looking at you and you're smiling, and I wish I could climb through the podcast and the screen and just give you a big hug because you look like you need it today.
I miss you, Jackie. You know, we got to see each other a few weeks ago, and it was so nice to actually clink glasses in person.
1 glass, 2 glass, 3 glass.
What happens in Charleston stays in Charleston. It's fine.
Exactly. So what's going on today, Shylie? How's everything?
I'm a little hot because the air conditioning in my building is having a little bit of a snafu. And the complaints from my coworkers here, not just in our office, but in the building entirely, really gave me inspiration for what I think we should talk about today.
I think that just means, take it as a good thing. It means summer's right around the corner, the weather's warming up, and it's...
Honey, I'm in Florida. Summer's been here for 3 weeks.
That's right, you're in Florida. Good thing for me. I don't know what to tell you.
I think that its turnabout is fair play, since usually I'm bragging about our weather. New Jersey is probably much more comfortable right now.
Depends on what you gauge as comfort here in New Jersey. We're talking weather?
Sure, yeah. I don't know how
We'll go with it.
New Jersey is in general. But what I was getting at is I have a paralegal who I work with who is about to have her third child, and she says that working in a building that is very hot is untenable for her. And I was joking around about how, oh gosh, is there an OSHA violation? And I realized
no, the answer is no. There most certainly is not.
It made me realize I don't actually know a whole lot about OSHA, because whenever any of my clients call me and say, I have an OSHA complaint that I need dealt with, my first gut reaction is I'm going to call Jackie Voronov because she is our OSHA maven here at HBS.
Maven, I like it.
As one does.
I'm a maven of all things occupational safety and health. It wasn't my dream as a child to be like an OSHA maven, but I guess I'll take it. But I'm glad that's how when you think Jackie, you think OSHA. Those two things just go hand in hand.
I do. It's actually what you're saved under in my phone. It's not
Jackie
actually
OSHA?
It's OSHA. It's just OSHA Maven.
Or just Jackie Maven. Just take out OSHA. Now, I don't know about all things Maven and OSHA, but what I can tell you is this. I am glad that your first thought switches to let me call Jackie, because that's what people should always do. Your knee jerk shouldn't be let me try and handle it myself. Reach out to counsel and see what's going on. Let's get ahead of it and let's find out what issues are presented. And that's before OSHA comes knocking on our door. If you suspect, hey, listen, what can I do to make my workplace safe? Then you've already taken all the steps in the right direction. It's a great start.
So let's take our deep dive, but first let's make sure we are armed with the necessary materials. Do you have
a lychee martini?
Your lychee martini, yes.
I do. I'm ready. I'm always armed.
I have one as well. Extra lychees today because I'm feeling spicy.
Did I tell you that I've nominated you to be our Secretary of Lychee Martini Defense? There's a title that goes with it. You're like the lychee
that poor waitress in Charleston when I accused her of false advertising of lychees.
I'm sure it's not just I'm sure you have a wake of poor waitresses everywhere you go up the Eastern Seaboard.
No, I'm very good. I'm very good to people in the hospitality industry. I once was there. You shouldn't have lychee martinis advertised on your website if you don't sell them.
I agree with you. I agree.
Anyways, cheers. Okay.
Cheers to you. Cheers to me and OSHA and all things litigator and loungy.
Okay. So OSHA, I know that it stands for Occupational Safety and Health Administration.
Right.
What does that actually mean?
Exactly what it says. So the Occupational Safety Health Administration is tasked with making sure that all of the workplaces across the country are safe. And safety, a lot of the times people think that's in construction or that's in factory work or that's in high risk environments. And it's not. The OSHA Act applies to all employers, regardless of industry. So you can be working in the most calm, peaceful, dormant office anywhere, and OSHA.
In a Chanel boutique.
Yes, things get dicey in those Chanel boutiques. Sometimes you go in there looking for something in a size 38 and then they tell you they don't have it, but you see somebody just walk out the door with it and you start to throw down. Things happen.
Okay. And what are some of the things that you have seen as big issues with OSHA?
It's not so much coming from the agencies. It's what I've seen happen in the last probably year or so, or even a little bit longer than that, kind of in the wake of COVID. Employees have started turning to agencies wherever they can to lodge complaints. And sometimes it's the EEOC, sometimes it's Division of Human Rights, sometimes they file suit. But more and more employees think to themselves, if I raise an issue, and in my head, I feel like it's an uncomfortable work environment physically, they'll also start to get OSHA in the mix. And employees are doing that more and more. They're calling up OSHA or they're submitting complaints online saying, oh, my employer isn't providing me a standing desk and that's dangerous for my back. I've seen employees try and assert sexual harassment and discrimination claims through OSHA saying that they are experiencing psychiatric and emotional distress, all of the garden variety run-of-the-mill stuff they'll assert in a complaint, but they're now putting that in front of OSHA. And for the first time in 20 years, I actually saw an OSHA inspector come to a site and say that they had gotten a complaint of hostile work environment and harassment. And there he was. I was floored. I really was. I've never seen that before. They have no jurisdiction, but they'll do the investigation.
So people will say things now like, I've been harassed through electronic means, or I'm being threatened through electronic means, and my workplace has failed to keep me safe that way, and it's a dangerous work environment, and they'll actually report it to OSHA.
They will. They'll report it to anybody who will listen. So everybody's a keyboard general. They'll submit any complaint anywhere as long as it allows you to hit submit. Now, 99.99% of the time, OSHA's not going to come out there and give that any shrift. But in this one case, I was surprised to see that they did. And they tried to piggyback it onto an excuse to get in the door and see if there were workplace violence issues, to see if there was a compliant plan. But employees are complaining. This doesn't come as a surprise to anyone. We live in a vocal world.
So let me ask, because when there's an EEOC complaint, you get a letter or you get a charge and it's all done electronically. And I've never actually met an EEOC investigator face to face. Obviously, that can be very different with OSHA, where you have representatives who want to come do an actual site visit, right?
They'll do it unannounced. They'll just show up. They'll hear, oh, hi, here's a card. I'm with OSHA. Or they might not even show you a card. They might tell you they're with OSHA. And at that point, you're within your rights to say, well, can I see your ID? Can I see a card? Can I show you? I've seen somebody actually show up to a nursing home pretending to be from OSHA, trying to dig for information. It was somebody who got their brother to get in on the scam. So if you're an employer who gets a knock at your door from a surprise investigator telling you they're here for an inspection, ask for confirmation and make sure they are who they say they are.
Are you able to then call a number or call a supervisor at OSHA and confirm that this person is supposed to be here and that's what their authority is and this is who they say they are?
You can. Yeah, sure. Usually somebody will have a card or an ID, a form of ID that they can give you. If for whatever reason you don't think it's convincing, sure, you can call and find out.
Okay. And so typically if they do an unannounced visit, do you have some idea that somebody has lodged a complaint against your business first, or might be the first notice that you're going to get that an employee lodged a complaint?
It's typically because an employee lodged a complaint. And it doesn't have to be in detail, but it's, again, 99% of the time because somebody filed a complaint and said something was afoot in the building, in the organization, in the company, could be for any reason.
And what are they allowed to do? Once they've identified themselves, what are they allowed to do? And what is an employer's option? Should the employer call you immediately and say, hey, Jackie, get over here. I've got OSHA here.
Yeah, just like what you do. You should say, I got to call Jackie. I got to call the OSHA maven. Everybody should have best practices and a protocol for responding, because presumably the employer already has policies in place. If you're a hospital, if you're a nursing home, you've got infection control protocols in place. If you're a construction site, you've got your foreman, you've got your safety supervisor, you've got those policies in place. Whoever is in charge of that department, immediately get the supervisor. OSHA most likely will be showing up and they'll already ask to talk to that person. So you presumably will already be in front of them. But if you can, immediately reach out to your general counsel, your in-house counsel, your risk managers, the general managers. Escalate it up the highest chain of command that you can before giving a response to anything. Sometimes people don't know any better. Sometimes they'll be panicking on the spot, and the investigator will come in and say, I want to see all your records. I want to see all your safety manuals. Show me the machine, show me the device, show me the mixers, show me whatever. And they'll just take them in and give them carte blanche. You shouldn't do that. I'm not saying by any means don't cooperate, because you should. Once OSHA's in your door, you do want to be cooperative. If you've got nothing to hide, there's no reason not to be. But do give notice and let us know so that we can deal with it.
And if they come in and they say, do they have to tell you what the complaint is? Like, we've received a complaint that you're not giving people hard hats or something like that.
Yeah, they will tell you, because they're not just there saying, hey, open the door and let us poke around. They'll tell you specifically what they're there to find and see and what the complaint was. They'll tell you. They're not going to tell you who it was, because they don't want any retaliation issues. Sure. But they'll tell you what it is.
But that's my question is, let's say they get a call that you have no guards on your wood shaving cutter or something like that, and they come in and they're looking presumably for wood shaving cutter guards, but then they notice that your employees are running around without protective gear on. So can they then expand the scope of their investigation or expand the scope of their search if they observe something else that would be potentially a safety hazard?
Sure, they can, they do, they will. Once they're in the door, they're going to, whatever is observable and readily they can see, they're going to start peeling that onion back. That's why you should always reach out. You should have these processes in place for dealing with that, knowing that their potential exists. What to do. It's like an evacuation plan. What do we do in the event OSHA shows up at our door? Step 1, breathe, don't panic. Most of the time, this is easily addressed and easily resolved. OSHA comes in pretty targeted. They don't want to, although they don't want to take the roof off the place. They do want to just focus on what the target of the investigation is, the subject of the complaint, but just be direct, be cooperative, be polite, be friendly. There's no reason not to be. It shouldn't be a contentious encounter at all.
And then do you have the opportunity through your counsel? Does an employer have the opportunity through counsel to respond to whatever the complaint is? Do they get to actually know the substance of the complaint and respond?
So I wish that there was a more formal process in place, but there isn't. It really all depends on the investigator. Sometimes the investigator will say, all right, here's what the complaint is. And they'll tell you, I want to see these documents and I want to interview these employees and I want to do X, Y, Z. The best response to that is, okay, we'd like to have counsel here present. This is what we have counsel for. If they ask for documents on the spot, ask them to put it in writing. Okay, because a lot of the time it's confusing. Sometimes they'll ask for documents and somebody might not know better and you'll give them all your records. Ask them, say, okay, you know what, send me a letter and we'll get you everything that you're looking for. Remember, you don't have to panic and do everything on the spot. Just say, we'll give you what you want. We'll give it to you freely, but we want to make sure that we have counsel involved and we want to make sure we have a risk manager involved, your general counsel, the supervisor. If this is a lower level position, they shouldn't be handling it.
So my understanding from the very limited research that I did on OSHA to be able to ask you some relatively intelligent questions, I hope they're intelligent questions, is that they can do an investigation, OSHA can do an investigation, and then they could find there to be problems and issue citations and also impose penalties, correct?
They can. Those penalties will be economic, and will involve some level of abatement and remediation of whatever the problem is. But remember, that doesn't all happen in one day. The investigator themselves, a lot of the time, isn't necessarily an expert in the subject matter of whatever it is the complaint was, because there's just so much. Think about it. It can be infinite. Employees can complain about anything. A window isn't opening all the way, a door is jamming, and we can't. There might not be a standard. So OSHA has the opportunity to come out there and collect information, to do an investigation. They then have only 6 months to issue a citation for whatever the offending conduct is or whatever the violation is. But they'll take the time. They're not going to do it on the spot. They're not just going to come knocking on your door and say, oh, let me look around. Here's a $5,000 penalty for this or a $5,000 penalty for that. They're going to collect information. They're going to talk to other employees. They're going to do they're going to do the workup. And at that point, then you might receive a citation and notification of penalty. But not always. Sometimes what will happen, OSHA, they have broad leeway. So that any one of the following things could happen. OSHA could get a complaint and they might send you a letter and say, please be advised, we're in receipt of a complaint alleging you don't have I'm giving you an example. The auto safety switch on a mixer isn't shutting off. Somebody could get their hand stuck in it. Please do your own self-audit, do your own self-investigation, report back to us, tell us your findings, give us your documents, and then we'll evaluate. And then they'll probably or potentially close it out. That's option one in response to a complaint. Option two is they'll actually have somebody come out, like we've been talking about, knock on your door and do an investigation. And that investigation will continue over the course of weeks or a couple months, at which point they'll give you their conclusions and findings. They might close it out. They might say, we didn't see anything to sustain a violation for any standard. Citation and a notification of a penalty. And then from there, a number of different things can happen. So there's always a variety. OSHA keeps things interesting.
And since we are now in a new administration and we have experienced massive executive orders, shakeups within the Department of Labor, shakeups with the EEOC, the NLRB, what are you seeing? And I've done just a little bit of research so that I could talk to you somewhat intelligently about this. What are you seeing as changing now in this term? I see people talking about the fact that the OSHA commission, doesn't actually have a quorum.
Can I tell you, a few days ago, if you had asked me this question a week ago, I would say I haven't seen anything different. But sure enough, as luck would have it, the other day, and this segues into it, it's not OSHA specifically because I started digging into this. I had an NLRB issue and a labor issue. And typically, whenever you're dealing with unions in the height of collective bargaining, or there's a problem and you're going into new contracts and you're negotiating, they have what's called the Federal Mediation Conciliation Services. So before a union is allowed to go on strike, they have to notify the Federal Mediation Conciliation Services Department. And every region in the country had its kind of compartmentalized department of that central office. And I'm going somewhere with this, I promise. And we got a correspondence from Region 1 Commissioner, and originally about a couple months ago, and he said, I'm going to be the assigned mediator in this case. Let's get the ball rolling. So I try to call him a few days ago, and no answer. Phone has been disconnected, website has been removed, the emails are getting kicked back. And as I start digging, I called Central Command over in DC and I was like, why can't I get a hold of anybody in New Jersey? And they're like, that's because they don't exist anymore. Our department has been decimated. Decimated was her word, not my word. And from what I'm led to understand is that they've closed and shut down all of these field offices with virtually no notice. They certainly never told us, the affected parties that are involved in the bargaining process. And there's only 6 federal mediator and conciliation services folks left in DC now. They've gotten rid of everyone. And that's a really long way of segueing to your question about OSHA. And if I had to speculate, which this probably is entirely, I would think that there's same cuts have been made there too. But yeah, I'm seeing it. I definitely saw it on the labor side, and I would not at all be surprised. Great for me and great for employers. It's just less people to show up at your door and do investigations.
It's not like the cases go away, though. If they don't have a quorum in these administrative agencies, there's just a backlog that's growing and growing. It's not, sorry, we don't have anybody to take care of this, your claim is dismissed. It's just going to be this huge backlog until they resolve it or until there is some sort of administrative change.
That's exactly right. It just sits and it doesn't go stale and it doesn't go away. It just languishes and ferments. And then, unfortunately, we've had that situation happen on the OSHA side not in New Jersey, but I was handling a claim out of Pennsylvania, and I thought it was over. And sure enough, I find out 3 years later, it's still open because it was a response to an employee complaint. So one of the things I think I mentioned earlier, OSHA has 6 months to issue a complaint, but where an employee complains about retaliation, they're going to keep that investigation open longer until they can close it out.
OSHA is a federal scheme, so it's
there's both. Some states have state OSHA plans, like California has an OSHA.
Of course.
Yeah, so there's both. But typically when we think of OSHA, it's federal.
All right. So for the states that have their own OSHA schemes, do you anticipate that those state agencies are going to become even more proactive if there is a federal scale back? So if you have federal OSHA deregulating under directives from Trump, like the 10-to-1, eliminate 10 administrative rules before you can pass a new one, do you expect that the state agencies are going to become more proactive and try to fill the shoes of the federal agency?
I don't know. I don't know that the states have the capacity to do that. I don't see states just coming on board and picking up federal slack. I'm sure anything is possible, but these states are pretty inundated to begin with. So I don't think that, I don't see it. I don't see it happening. I think states are already bogged down and the backlog on a statewide level is already pretty severe, that they're not going to trickle down and say, congratulations, now that we've gotten rid of 3,000 federal employees, the burden shifts to you. I think that they'll just say, nope.
I think that the federal government's hope is we've deregulated it and it's going to stay a little bit freer and a little looser with less emphasis on administrative regulation. That seems to be what the push has been.
I don't know that it's deregulated. I think it's just we don't have the manpower to, not when I say we, the federal government, which is not we or me. I think that they're just cutting down on.
We fund it.
Yeah, it's definitely not we or me. But nothing's deregulated. The laws are still the same. And so I would never tell a client, and I would actually tell them, don't get comfortable. You should still continue to have your plans, your safety practices in place. You should still anticipate that an OSHA investigator or a state investigator can knock on your door really at any time. So don't get comfortable. Don't get lulled into this false sense of security just because we're living through a crazy period of time.
So maybe the better word than saying deregulated would be less stringently enforced currently.
Yeah, you'll see a little bit of maybe taking the foot off the
less stringently investigated
a little bit. Yeah, it really just depends. It's hard to say. That it may not affect you at all. Most people and most employers will probably get through life for the next 30 years and never have an OSHA investigator show up at all. So you probably won't notice a difference. And if you were somebody who had OSHA show up in the past, probably not having them show up 3 times a month. So you're not going to just be in a position to be like, I notice any appreciable difference. From where you sit as an employer, you'll probably never know. It's only where we defense counsel sit that we would notice it, where we'd be like, okay, things have been a little quiet. Why is nobody calling us? Maybe I can take my first day off in the last 2 years. There's nothing to deal with this week. We'll see it, but you, the employers, will not notice it at all.
That's reassuring. And Jackie, I think that you always give our listeners, the employers, some really comforting advice and some guidance.
Go on.
to
Go.
make them
Is that
feel
what
like the
makes
sky
me
is not
amazing?
falling.
The sky's not falling. It never is. There's really no reason to ever panic. There's a solution to everything.
There's not a reason to panic, but also maybe not as much of a reason to celebrate as people might think with administration changes.
Absolutely not. No, I don't know why people do. I get it because media and the news, and you hear things and people gossip and they say this means that we get to do whatever we want and it's a free for all and there's no enforcement. And that's absolutely false. I would tell you the opposite is true because people now, when they get comfortable like that, employees are filing more claims. They're complaining about more conduct. The discrimination and harassment claims are going up. Retaliation claims are going up. You now see more reverse discrimination lawsuits on the cutting of the DEI programs. So just because you cut one thing doesn't mean everything just gets quiet or easier. It just typically the response is more.
I think that there is a lot to watch. I really enjoy all of these executive orders that are coming out.
There's a lot,
There's a
yeah.
lot. There's a
At the
lot.
Supreme Court, your favorite lounge and in all things litigator and legal, they've got a huge plate on there. Are you watching this with like bated breath?
I'm actually listening in the background to oral arguments while I work. I feel really bad for Justice Roberts. I feel like he's very busy right now. And I think that it is an interesting time. I actually read this morning that Donald Trump has issued more executive orders in this presidency, second only to FDR during the New Deal. And so it's a really revolutionized way of governing. It is certainly different than what we've seen in recent years. And I think that I think one of the areas that it is going to have the biggest impact is labor and employment, because so much of labor and employment is regulated by administrative agencies. And that's where he is focusing a lot of these executive orders.
Yeah. And you also start to see with the shifting and the changing of the guards on the bench, you see different interpretations of laws that have been on the books for decades, but with the new judges are interpreting them and handing down decisions differently than you might expect in past years. But from where I sit, I'm really eager to hear the Supreme Court's opinion that should come out soon. Oral argument was in February in the Ames versus Ohio Department of Youth Services matter. And if you're not familiar with that one, that's a reverse discrimination claim where a heterosexual woman claimed that she was demoted and ultimately didn't get a job because of the fact that she was a heterosexual woman, and then it went to a gay man instead. And now the question before the Supreme Court is whether in reverse discrimination lawsuits, you do have to prove what's called those background circumstances to prove that you were, and I say that in air quotes, those background circumstances to prove that even though you're in the majority, you were still discriminated against, right? There's a split in the circuits. So I'm really curious, so eager for that decision.
That's taking a playbook out of Ruth Bader Ginsburg. That's taking a page out of Ruth Bader Ginsburg's playbook, because that's how she started advancing women's rights when she worked for the ACLU. And it sounds very similar to the on-cal decision on men's sexual harassment at work. This is going to be
It'll be landmark,
landmark, groundbreaking law. So.
Yeah. So as soon as we get a decision on that one, you know what that means. It means lychee martinis are going to start flowing freely, and we're going to have to reconvene in the lounge.
I think it'll come out probably in June, don't you think?
Probably. That's usually when you start getting all the decisions.
The big ones.
Oral argument was February, so around June. Yeah.
I thank you, Jackie, for giving us a brief crash course, but not actually crashing at work, because that would be an OSHA violation.
Womp
On
womp.
OSHA. What?
Womp womp. Good one.
I'm really punny.
Very funny.
And we look forward to doing some more deep dives into some other administrative law issues in the future. So thank you all for tuning in. If you have any questions or comments, please feel free to reach out. If you have any burning employment questions, let us know. And until then, cheers.
Cheers.
Thank you for joining us on Litigators Lounge. This show is brought to you by Hall Booth Smith, helping clients navigate the complexities of workplace legal issues. For more information, go to hallboothsmith.com.
Litigators Lounge is a production brought to you by Hall Booth Smith. This podcast is published for the purposes of providing general information and education on topics which include those related to the law and legal issues, but the contents of this podcast do not constitute legal advice. Listening to this podcast or utilizing the information contained in it in any way does not constitute, nor does it create, an attorney-client relationship between you and Hall Booth Smith or its lawyers. The contents of this podcast should not be used as a substitute for competent legal advice from a professional attorney licensed in your jurisdiction.